Good morning, everybody. May I have your attention, please. Welcome to the Constitutional Court. Court is about to start. Please make sure that you switch off your cell phone, please. Thank you.
Sorry, thank you. I appear on behalf of the applicants, together with my learned colleagues, Advocate Gift Chakwana and Advocate Sureya Govender. Thank you.
As it may please you, Deputy Chief Justice and Justices of the Constitutional Court, I appear for the amicus together with my colleagues, Advocate Gofa, Lewakeng, and Advocate Mokwala.
Thank you, Mr. Mjapita. Mr. Naidu?
Thank you, Justice. In making submissions on behalf of the applicants, I am mindful of the fact that even though this matter is an unopposed matter, this court has to be satisfied that a case is made out for the relief which is being sought in the notice of motion. In doing that, I would want to first go through the fact that the applicants are of the view that confirmation by this court of the relevant order of the High Court as sought in the notice of motion would be sufficient relief for the applicants. The other aspect that needs to be addressed is the fact that the respondents in this matter were not supine. There is a litigation history and trajectory by which this matter comes before this court. There was first an urgent application before the High Court where the matter was argued, counsel represented both sides, and the interim order was granted by Matenjwa AJ. Then there was a second round of hearing where there were full set of pleadings on both sides before the court to be considered, together with heads of argument, comprehensive heads of argument by both sides. And the judgment, for instance, in the urgent application is at volume 7, page 580, and the final hearing before Singh AJ is at volume 7, page 606. And at paragraph 25, the learned judge records the fact that both parties were represented by multiple counsel led by senior counsel, and the nature of the submissions that were made in support of each side. Finally, after those comprehensive heads and comprehensive material before the court was considered and a judgment given, the matter went on appeal to the SCA. Now, at the Supreme Court of Appeal, comprehensive heads of argument were filed for serious consideration by the other side, and by the court, and at the doors of the court, the matter was finally settled. The parties entered into an agreement. At the Supreme Court of Appeal, the relevant respondents conceded that the legislation under attack was indeed invalid for want of compliance with the relevant provisions of the Constitution, namely Section 30, 31, 211, and 212. This concession by the legislature that its legislation is flawed and does not comply with the Constitution is a material matter to be taken into account by this court. In the application before this court, we set out the basis on which the application comes before the court and ask for an order in terms of Section 172 2D, and this is found in the application itself, discussed at page 8, paragraph 22 and 23 of the application. In short, we submit that the Umdeni Wenkosi is, through the legislation created by the legislature in Kwazulu-Natal, excluded from playing the role which it is entitled to play in the removal of the Inkosi, or the traditional leader in this matter. At this stage, I would pause to mention that because the Umdeni Wenkosi is mentioned so many times in the papers, it behooves us to look at the definition of Umdeni Wenkosi given in the 2005 Kwazulu-Natal Act, which is to the effect that Umdeni Wenkosi means the immediate relatives of an Inkosi who have been identified in terms of custom or tradition, and includes, where applicable, other persons identified as such on the basis of traditional roles. So it's not merely just the immediate family of the Inkosi involved. Insofar as our submissions are concerned, I would then go to the heads of argument in this matter. In our heads of argument, we set out sorry, I beg your pardon. Oh, they're here all the time. We submit that on the basis of the record before the court, there is no dispute that the Umdeni Wenkosi is a body which is the decision maker in the appointment and also in the removal of an Inkosi. And this aspect is dealt with in some detail in paragraphs 2, 3, 4, and 5 of the heads of argument. Now, I need not indulge in any readership of those, save to point out that the role of the Umdeni Wenkosi is succinctly set out there. The other important aspect to be taken into account by this court is, what was the KwaZulu-Natal legislature in fact doing when it made this legislation, that is the 2005 Act? It was giving vent to the traditional authorities, the traditional communities, their rights in terms of section 30, 31, 211 and 212 of the Constitution. For that purpose, one has to establish what is the customary law. Is that customary law respected by this particular community and has been applied and governed this particular community? One finds, yes, indeed it was. And that is set out in the expert report, also before the court in the record, at page 2, volume 3, page 252, paragraph 7.2. The expert, if we may quote him, in fact says the following: the Luthuli royal family had the power to remove and to appoint the chief. This is an unequivocal, unchallenged statement made by the expert, which the respondents have now come to accept as the correct state of the law. And this is again repeated for convenience, I may add, by the expert at page 257, paragraph 8.5. The previous paragraph was at 7.2, and in this one, he says, the senior members of the Umdeni Wenkosi, this council, that is the Umdeni Wenkosi, had the final voice and the right to appoint, discipline, and remove the chief. So, before the court on the record, we have what the customary law is. And we have the legislation which is supposed to give life to institutionalize, so to speak, that customary law. And we now have reached a stage where those who made the law agree and concede that they failed to abide by the precepts, the dictates of the Constitution. We then deal in our heads at paragraph 16, 19, and 41 of the heads as to what the customary law is, and that this is in fact not in dispute. At this stage, I would go to a further aspect, that namely, it is admitted in this application that the legislature has failed to comply with its mandate, and for the purposes of this hearing, I would recount certain precedents where we have a situation where the respondents are not in court today. We find that in, for instance, Delanga versus Smuts, NO, in this court in 1998. What transpired is that the legislation which was under attack was Section 63 of the Insolvency Act. And Chaskelson, the president of the court, then invited Dalla Omar, the Honorable Dalla Omar, the Minister of Justice, to come to court and make submissions or comment on the attack on the legislation, because he was not, in fact, before the court. The minister was given advice that the challenge is well-founded. But even though the challenge is well-founded, at the hearing before the High Court, the minister was not represented and the minister's views were not before the court. And therefore, the minister then was advised that he, as the keeper of the legislation, should go to the Constitutional Court and say why that legislation should be upheld. So we then came to court and made the submissions together with our learned colleague, Masipa, the advocate at that time, later Masipa J. And the court then had the benefit of heads of argument for the first time presented to the court, even though the minister's view was not available to the court in the High Court. Similarly, in the Bogoshi matter, where the notion of strict liability was eventually jettisoned in around 1999, the court there found itself in a position where the notion of strict liability was jettisoned in the country of origin, namely Holland. It then sent letters to counsel of the parties involved to prepare on how should the SCA, the Supreme Court of Appeal, deal with the fact that the cradle for the notion of strict liability has rejected that branch of the law, so to speak. And so heads of argument were made available to the Supreme Court of Appeal. And finally, closer to home, more recently, in the Scalabrini matter, where we were again involved, one finds that there was a full hearing with full papers before the High Court in Cape Town in the urgent application. Both sides filed heads of argument. The High Court then held that the legislation in the Refugees Act was invalid for want of compliance with the Constitution. At the final hearing again, heads of argument were presented, the hearing was full-blown, and the Minister of Home Affairs put his case before the High Court fully, and that case was considered by the High Court, which then again ruled that the provisions of the Refugees Act fell to be declared unconstitutional. In this matter, one finds that when one then came to the Constitutional Court in the Scalabrini matter, on behalf of the minister, we came to the Constitutional Court to explain to the Constitutional Court the basis on which we present no heads and we do not oppose the confirmation of the order by the High Court. We submit that these precedents should also guide us in making a determination in this particular matter. And that is to say, the view that the government, the legislature which formulated the legislation is now supine and not heard would not be wholly true, because it was fully heard, it made its position well known, and it is on record as to what its position is. And given that, we would submit that the legislature itself has taken the view that the best way to deal with this is for this court to grant an order in terms of the notice of motion. And that notice of motion is crafted in line with the agreement reached between the respondents and the applicants. Respondents who conceded the position which is to be taken into account by this court. And after having conceded, they agreed that this is how we can neatly and swiftly resolve the failure to comply. And we submit that at this stage, I do not deal with the submissions to be made by the amicus, other than to say that if one considers the amicus's position, one finds that a suggestion is made that an alternative means should be dealt with. An alternative path should be carved as to how to resolve the impasse, so to speak. We submit that the persons best suited to comment on that would be the respondents, who are the makers of the legislation, and whether or not what they have agreed to and what they have put before the court and conceded, whether this reading down or reinterpretation, so to speak, of the legislation is the best. So at this stage, we submit that, given the precedents we have just touched on, the respondents, it would be fair that they be heard only if the court is in any way persuaded that there should be a departure from the suggested solution to this problem. And we submit that the suggested solution is in fact a good one, more particularly because before the court we know what the customary law is, and before the court we know that the legislation simply did not give vent to the customary law. One finds that in the case made out in the application by the applicants is that the Umdeni Wenkosi should be given a voice in the decision-making process. But in our heads of argument, we go further and we say, advisedly, based on information and the expert's report given under oath by the expert, that the previous approach to this question doesn't tell the whole story, more particularly because the Umdeni Wenkosi is the decisive voice. It is not a person who should be given a hearing. No, it is the body that makes the decision. It is not the body that sits on the sidelines and assists the premier or the politician to make the decision. And that I have supported with reference to the expert's evidence, which is before the court, and have referenced the volumes. These are the submissions I would make at this stage.
Thank you, Mr. Naidu.
Thank you. I would apologize. One last matter,
But you're finished.
and still within my time, is that because of the suggestions made, I would remind the court that this court is indeed the supreme. And when I saw the heads of argument by the amicus, I was then reminded of the earlier dates of first principles and would read just a little extract from the new constitutional and administrative law by Cora Hoekster, and at page 17 it says, "The advent of constitutional supremacy has had dramatic implications for administrative law and indeed all other branches of public law. As Chaskelson P. explained in the pharmaceutical manufacturer's case, the interim constitution was a legal watershed which shifted constitutionalism and with it all aspects of public law from the realm of common law to the prescripts of a written constitution, which is the supreme law. The change means also that the courts no longer have to claim space, push boundaries to find means of controlling power, to find means of controlling public power. That control vests in them under the Constitution, which defines the role of the courts, their powers in relation to other arms of government, and the constraints subject to which public power has to be exercised. No, in short, constitutional supremacy means that legislation, which is the principal means of conferring authority on administrative bodies and officials, must itself be authorized by the Constitution and may not violate any of its provisions. Any legislation which fails to comply with the procedural or substantive requirements of the Constitution will be invalid. The reason we referred to the pharmaceutical manufacturer's case at paragraph 45 here is simply that this court is called upon to make a clean solution, and that is to confirm the order by the High Court. Thank you. That now is my submissions.
You still have 5 minutes.
No, thank you. I thank you for the...
Thank you.
May I
Mr.
take an instruction? I will just make one statement my learned colleague asks me to make. I intended leaving this for later after the amicus has dealt with it, and simply it is this. The amicus's submissions at page 13, paragraphs 35 through to paragraph 41, in fact, support our submissions that there should be confirmation. I shall not tarry by dealing with that at this stage because the amicus would first deal with the matter and then if needs be will respond. Thank you, Justices.
Thank you, Mr. Naidu.
Thank you.
Mr. Naidu,
Yes.
I didn't quite get it. My note says that, but it may be wrong, my note says that you think the amicus submissions on alternative relief, did you say they are good or they are not good? I'm not sure whether I got it right.
No, we say they are not good.
Okay.
They don't solve the problem at all because they have, well, the necessary words of learned length and thunderous sound and academic acceptance. But these are arguments which are placed on a plinth which simply doesn't support the arguments. And the reason for my mentioning it in that fashion is this. The argument is said to be this. The statute is there. Work with the statute to find a space and solution. In the first place, the legislation is supposed to be honoring the customary law. This legislation simply, in the aspects attacked, does not honor and does not even bring in customary law to be applied. It does not bring customary law into the mainstream. What happens is the legislation one is reading and dealing with is like stairs of sand. In other words, it does not correctly represent the customary law. The legislature has to now say, hold on, in this legislation, we have distorted and falsified the customary law by giving the decision-making power to appoint and the decision-making power to remove to the politicians, to the administrative officials, to EXCO, to the MEC, and to the Premier, who may not even be part of our community. And I do not speak wrongly when I say that this is a community which, through the Restitution Act, has been given some 10, 15 years ago, no less than 450 million rands worth of productive land. And who best to look after the land other than the family community to which the land was given? The reason I say family community is that a traditional community or of this nature usually they are all usually relatives, so to speak. That is the fundamental distinction usually between a community in general and a community which, as a tribe, made its claim for restitution in terms of the Restitution Act. And that is why we say that the foundation for the arguments advanced by the amicus is flawed and faulty. It cannot support any argument because the foundation, being the legislation, doesn't represent the correct customary law.
Now, if I summarize your argument correctly, just tell me if I'm wrong. You're saying that what the amicus is suggesting is that instead of declaring the entire law, impugned provisions, invalid, constitutionally invalid, the amicus is saying we should grant the Umdeni Wenkosi some right of audience, hear them audi alteram partem, through an amendment of the impugned provisions. You say that's inadequate. You say that doesn't solve the problem because all that would do is grant them audience, give them a right to be heard, and not solve the problem of decision making. Is that in a nutshell your argument?
That is indeed the case, yes. In fact, when one has recourse, just as an example, to for example, paragraph 47 of what the amicus says. From the amicus's perspective, a remedy that restores the Umdeni Wenkosi to its rightful constitutional role, firstly, through interpretation, or secondly, tailored relief better serves the Constitution than wholesale invalidation. Well, we say what the High Court has done is to give tailored relief. The High Court did not wholesale scrap the legislation in question. What it has said is these 4 sections or subsections need amendment. And you, legislature, know what the amendment should be. So that is a neat way of correcting this wrong. And what is more, the legislature also says, yes, that is the neat way for us to do it. These 4 subsections or sections in the legislation are flawed. They don't comply. Let us amend those 4. We're not throwing the whole legislation out, so to speak. So that is already tailored solution delivered, so to speak. And if one considers paragraph by paragraph the submissions made by the amicus, one finds that at the end of the day, out there where the public has to deal with a piece of legislation, one would have a situation where the legislation says, in so many words, the Premier, Kochta, the EXCO, and the MEC have the decisive voice. That's what the legislation says, and that's how it reads. So throughout the country, persons will have to go to a constitutional court judgment and reread those sections to say they have to be interpreted, read down or read in the following way in terms of the Constitution. We say that the solution here is this. If it is a distortion of the customary law, if it is false customary law which is legislated, which the legislature knows and concedes it should not have put onto the statute books, a clean break, cut it off, amend it, and that is the neater solution. And that is why you'll find, whilst these notions of reading in, reading down, amending, making suggestions may sound like solutions, they are in fact not solutions, because the amicus itself should have said, this provision should be read down in the following way. And let us look at how do you read it down and what do you say. We have no solution there, because we submit that there is no reading down when the legislation is completely false.
Can I just move on and ask
Yes.
you about, I mean, I hear your submissions.
Yes.
It doesn't mean I'm entirely satisfied, but just on the amicus's criticism of the High Court's approach. The amicus says, what the High Court did was, using the Grootboom judgment of this court, it examines the reasonableness of the impugned provisions as against sections 30 and 31. They say there should have been an analysis, A, where the rights were infringed, and then B, the next step, a section 36 analysis, justification analysis. And that is lacking in the judgment. What do you say about that?
What I say about that, with respect, Justice, is this. Are clear. When the customary law says A, B, C, and the legislator, for its own purposes, has simply said A, X, Y. In that kind of situation, one assumes that the legislature is supposed to be bona fide in what he does. We submit that it is manifest that there was a theftus act by the legislature to steal the power which reposes in the hands of the Umdeni Wenkosi and place them in the hands of administrative officials for the cases. That is why we have placed before the court the CASAC case, which demonstrates to the court how legislation can be used by administrative officials to divert benefits away from the community who are entitled to those benefits. And if it is clear, where is there a need for, so to speak, to go around trying to catch one's own tail through analyses in circumstances where the facts clearly show that you need to lop off this rot and start again.
Section 36 doesn't apply here at all.
My Lord,
And if so, why?
yes.
Tell me why you say it doesn't apply.
I'm not saying it doesn't apply. What I'm saying is, on any analysis, one finds that this legislation simply does not represent the customary law which it is supposed to represent.
Let me deal with one last question. I heard you arguing that if this court is minded, and again, I may not have heard you correctly, if this court is minded to adopt the approach that the amicus proposes, in other words, look at reading down, and in some instances perhaps even reading in to the impugn provisions instead of striking all of it down, which you say we shouldn't do.
Yeah.
If the court is minded to do that, then the minister and, the premier and the executive council and so on should be the ones to be heard on that. Well, I want to ask you about section 172. Our powers, once we've struck down legislation as constitutionally invalid, grant any order that is just and equitable. Why should we, when respondents calculatedly choose, despite this court having said many times that they should come to court to explain the legislation, they choose not to come, why should we then hold back and say, we think this is a just and equitable order that we should make, even in the absence of having heard them, because we've heard the amicus, which we've invited as a court to come and argue.
My Lord, in this matter here, Justice Majid, in this particular matter, what we are saying is this: the legislature and its representatives have entered into an agreement which we submit is binding on them, but not binding on the court when the court is asked to make an order. Contrary to what was envisaged by the legislature, that is the respondents. And that is why I used the precedents, the previous precedents. And in the precedents I referred to, first invited the minister to say, we want to hear you on this. And so the minister came. We have another situation where the law is to be changed, and the parties involved in the law before the High Court were invited to make representations. In this court, there was no indication from the court that, to the respondents, for instance, that this is how we are going to view the amicus's suggestions. And we are in the...
Understand, sorry to interrupt you, I don't understand. Why should we do that? This court has, this section 172 has been called in cases in the judgment of this court as wide as possibly can be imagined, within the confines of the rule of law and the powers of the court, the legality principle, of course. Why should we ask the minister to come and explain why we shouldn't make a certain order? I mean, I don't understand that sufficiently.
One of the reasons that come to mind at this stage is this. The amicus furnishes a response on Friday evening. It comes to the attention of the applicants, to everyone on Saturday. In other words, a court day but one before today, this new suggestion arises for the first time. And if this new suggestion, this new path, is one which the Constitutional Court feels that it is persuaded and finds it persuasive, then in the scheme of its process, it hasn't given an opportunity to the effective respondents to be heard on that. And that, we say, is all about the notion of fairness and audi alteram partem. It is not a process which is normal, so to speak. It is a process brought into operation by the Constitutional Court, the timelines and so on. So if this completely new path, what one expected is, now I merely speak on behalf of the applicants in this matter to say that an agreement was struck. It's an unopposed matter before the Constitutional Court. And now the Constitutional Court says, we have brought in, I don't want to say a spectator, but an amicus who turns the whole relief sought on its head. And therefore, the persons best able to comment on this are the persons who were engaged and soaked in the actions throughout. For instance, the amicus makes submissions that the Inkosi was represented at the inquiry, when in fact the Inkosi was not represented at the inquiry, in terms of which he was found to be guilty of these so-called offenses. And also, the amicus says there was this finding of guilt, but the record shows that the evidence there before the tribunal, which wrote a so-called judgment, relied on hearsay and the...
Those are things that we can see for ourselves, Mr. Naidoo.
Yes.
We can read the record and see it for
Yes.
ourselves. We don't need anybody to come and tell us. Anyway, thank you. Thank you.
Yes.
Thank you, Mr. Chair. You may have dealt with this, but just for my understanding,
Yes.
what is the role of Umdeni Wenkosi? Is it the sole decision maker insofar as a removal or withdrawal of recognition, or what? At
Yes.
what stage, if they are supposed to be consulted, at what stage of the process must they be consulted?
No, we say what they have found to be acceptable, we articulate in broad terms in our heads of argument, if I may point to that, in paragraphs 2, 3, 4, and 5. And if I may articulate it, in terms of the 2005 Act, the Kwazulu-Natal Act, it says only the Umdeni Wenkosi is the only body, the only person who may identify who is to be the next Inkosi. After it has identified, it then, as a formality, asks the Premier to appoint the person the Umdeni Wenkosi has identified as the next Inkosi. The Premier then acts as, and we have said, in the nature of an auditor in paragraph 7. He says, has there been compliance with the customary law? If the Premier finds that there was no compliance with the customary law or some other complaint, then the Premier sends this back to the Umdeni Wenkosi. The Umdeni Wenkosi then, as the keeper of knowledge of the customary law from time immemorial, then assesses what the Premier has said, and then makes a final decision and tells the Premier, we have considered what you have said, and we have changed our mind, now appoint so-and-so, or we have considered what you have said, please go ahead and appoint the person we identified, because your reasons are not sound. So in that process of the customary law, it is the Umdeni Wenkosi which is the sole and final decision maker. One may postulate that if there is anyone who wants to make complaints, then that person would have access to the courts. But confining ourselves to the powers of the Umdeni Wenkosi, that is what we say should happen. And that is why the roles of the Premier and the Umdeni Wenkosi in these subsections are reversed. And it is that reversal which we complain about. And it is that reversal which the legislature says, we have no doubt, will be corrected in line with the judgments.
Thank you. Let's look at section 21, the removal of a traditional leader.
Yes.
Explain to me the relevance, whether of sub 2 of section 21, which says that whenever any of the grounds referred to in 1A, B, C, D, and E come to the attention of Umdeni Wenkosi, and Umdeni decides to remove a traditional leader, Umdeni may, within a reasonable time, through the relevant customary structure, inform the Premier and furnish reasons for
Yes.
such removal.
Yes.
You don't have a problem with that because Umdeni is involved. And it relates to all those
Yes.
grounds. And then the 21.4, it refers to D, E, and F,
Yes.
which would have come to the attention of Umdeni Wenkosi ordinarily. So I'm trying to understand, because it seems as if Umdeni, in this particular paragraph,
No.
may have been involved,
Yes.
may be aware of the misconduct. And so what is the problem with subsection 4 of section 21?
The problem with subsection 4 in this particular context is that in respect of D, E, and F, it is not the Umdeni Wenkosi which makes the appointment in terms of section 23. Section 23 then says, whenever there is reason to believe that a traditional leader is guilty of misconduct in that he or she, one of these things, the responsible member of the Executive Council must charge. If one is talking about any amendment with respect, and if one talks about any amendment of this aspect, it is the Umdeni Wenkosi who must then be repeated in section 23. So indirectly, through the back door, so to speak, section 23 removes the entire power from the Umdeni Wenkosi and places it in the hands of the member of the Executive Council. So what happens in that case is, it is the member of the Executive Council now who makes the decision. And curiously, when one has recourse to what D, E, and F are dealing with, it is so wide, it deals with everything. In other words, you are able to deal with A, B, C, and whatnot, but the manner in which things are defined and described in D, E, and F opens everything to the power and scrutiny of the MEC. That is where the problem lies. So if the MEC there is, with respect, replaced by the Umdeni Wenkosi, that would effectively, so to speak, address the problem which the Umdeni Wenkosi comes to this court with. I beg my lady's pardon, when previously addressing the question, this aspect escaped me, but that is the nub of the complaint, yes.
Mr. Naidu,
Yes,
I'm sorry to take you back to your debate with Justice Mhlandla just
Yeah.
now. If there's a problem,
yes,
your problem with section 21.4 is reference to section 23 only,
yes.
why does section 21.4 have to go? Why can't a correction be done on section 23, not section 21? Because section 21.4, as I read it, there's no problem with it. But if you say that it is only because of reference to section 23,
Yes.
shouldn't the focus then be on section 23?
I would submit that the reason for this agreement, so to speak, is because of the tie between subsection 4, that is 21.4, with 21.3. And I would, with respect, submit that if 23 is cured, so to speak, it would naturally and sensibly cure section 21.4.
Okay, let me take you back to your, I hear you, but I'm still
I beg-
reflecting on
yes.
Yeah, I'm not getting this, but I'm reflecting on it. Section 20, what you were discussing with Justice Majid,
Yes,
you punched holes on the participation of the amicus in this court, and you said something about their submissions. But what I didn't get from you is what you want this court to do about the participation of the amicus and its submissions.
no.
What do you want us to do? Yes, you've said that you only received their submissions late, and when you were preparing for this matter, you thought that is unopposed and all of that. I've heard
Yes.
you. And their submissions, we've looked at them on paper, but my question is, what do you want us to do under the circumstances?
Yes. Justice Shikwi, when I was addressing the question by Justice Majid, I was at a place where the amicus is of the view that there should be a reading down of the provisions. At heart, what we were saying is that there should be a amendment of the provisions.
Yes,
The nub,
yes,
the nub of my criticism,
Can I interrupt you
Yes.
just a bit? I think you've had a debate with Justice Majid
yes,
about what the amicus is saying
yes,
and what you are saying on the
Yes.
other hand. But my interest is that, yes, they are here now, they've made these submissions, and you were told and on short notice, or you only heard about their participation late in the day. But what I want to get from you is what we should do
yes.
about the amicus's participation.
May I approach the question on the following basis? At the time of my debate, I pointed to paragraph 47 of the heads, the submissions by the amicus. And there the amicus suggested that there should be interpretation or tailored relief. I then focused on the fact that the High Court effectively is tailoring the relief by saying, deal with these 4 sections or subsections. Subsequent to that debate, and one of the problems are highlighted with this suggestion is that no concrete suggestion is made as to how this is to be achieved. And therefore, I made a submission that a clean break and redoing of the provisions would be the ideal solution. But since the further discussion with Justice Mhlantla, I have come to realize that if one addresses these subsections in the manner we debated, that may in fact resolve the issue. In other words, if the problem faced by the applicants is indeed solved by a rewording or reinterpretation, so to speak, of any section, if those problems are solved, then the applicants will have no complaint with the suggestion of the amicus. What we were saying is the persons best able to comment on this would be the actual respondents, who are the lawmakers, the persons who made the law, on whether that suggestion made by the amicus is a good one or not. And no opportunity was given to those persons for the solution.
Yeah, I heard your debate,
Yes.
Justice Matri, and I heard you agreeing with him that this court had the right to call for amicus's submission.
Yes.
What I was not clear about was the fact that you then traced when they participated, and you then looked at their submissions. And what I was not clear about is what you were recommending or submitting we should do as this
Yes.
court. Because you criticized as well the fact that the respondent is not there, because you were saying that what they are saying should have been said by the respondent.
Yes.
And what I was simply asking you is whether you've got something that you submit this court should do in the circumstances.
Yes.
But, unless you don't have it, then I want to move on.
No, in fact, may I just take have a discussion on that very briefly, just one question. And in other words, should there be a calling in of the legislature on this or not? I will respond to Milady right now.
They didn't follow. We can't. They're not here. Discussion. It's not it's okay.
What we say on that is this. The legislature has made a concession. And the concession which it has made is that the legislation which it has crafted should be struck down so that it can make new legislation. This court, of course, is not bound by that. Now, if this court says that something different and unexpected to the legislature is being given weight by this court, then the respondents should be given an opportunity in justice to be heard. That is the submission I make. Only if this court is saying, I'm now changing, so to speak, the legislature's concession by saying that we are going to accept the suggestion made by the amicus. The position I advance to the court is this: if the court accepts the position of the amicus and it solves the problem faced by the applicants, namely of taking away the decisive power from the Umdeni Wenkosi where it resides in terms of the customary law, if any manner the court deals with it and resolves that problem of the applicant, then the applicants have no problem with that. And it's only a question of whether there is a balanced view in regard to the concession made by the legislature, which has said that it perceives that these should be set aside. If the same effect is achieved by some other means, that is, to answer the problem of the applicants, we have no problem with that. And I would submit that in order to let a balanced view, so to speak, be had by the Constitutional Court, even without any further hearing, if the legislature wants to make submissions, this court is at large to call on the legislature to say, you have said this has to be confirmed. We take the view that this is how it should be dealt with. Do you have any comment on it? Let us hear from you by so-and-so date. These are solutions I'm suggesting from the bar. But my foundational submission is that if this court deals with the matter in a way that gives effect to the customary law, in terms of which the Umdeni Wenkosi has the decisive voice, as indicated, for instance, in dealing with substituting, for instance, in 23 sub 1, the Umdeni Wenkosi for the MEC, prima facie, while standing here, it seems it would solve the problem of all three of those subsections we are talking about.
Okay, thank you, Mr. Knight.
Thank you.
When you were having a debate with Justice Majid,
Yes,
both of you debated the powers of this court,
yes,
Section 172, so let's not go back to that.
yes,
But I'm simply highlighting again to say that we've got these powers as this court.
yes,
And the second thing that you discussed was that Justice Majid did remind you that we have in the past, as the state, in this kind of matters, to be present in this court, at least
Yes.
to give us
yes,
their own information, so that we can decide these matters fairly. That's all I'm going to say. They are not here now, and you are saying
Yes.
we must, in spite of the fact that we have said they must be present, and invite them again. I'm not going to argue.
no,
that.
sorry,
Well, invite them, in spite of the fact that we have said so in the past, not in this matter.
yeah. My lady, that is why I mentioned the precedent, and two of those precedents were the one in Delanga versus Smuts, where we came to court to present the minister's view, and in the Scalabrini matter more recently, year before last, it was an unopposed matter, but we came to court to answer the court's queries and questions. I am not making these as submissions and demands that we press. These are suggestions I make from the bar. They're not binding on this court, one. And two, the foundation of my submission is that any manner used by this court to restore the decisive voice of the Umdeni Wenkosi in this scheme of removal and appointment of Inkosi, if their decisive voice is restored, then we have no complaints, my lady.
Okay, thank you. Perhaps one last question.
Yes.
In your application, did you object to section 24, 3 and 4? Did you challenge those provisions?
Section 23.
For 3,
Section 21(4), Section 22, Section 23, and Section 24 sub 1.
yes, but I'm saying, did you challenge 3 and 4? So I just want to make sure that you didn't.
When you're
Ask-
talking about 3 and 4, you're
Yes.
talking about sections 3 and section 4.
I'm saying 24, 3, sub 3 and sub 4.
Milady is making a referral to section 24 sub 3 and sub 4.
Yes. Are they constitutionally compliant?
Milady, I would submit that by implication, when we say section 23 is to be struck down, that has the effect of dealing with section 23 sub 3.
I'm saying 24, sub 3 and sub 4. I think you can.
No, in the application, that was not specifically.
Hence, I'm asking whether
Yes.
they are compliant, whether they are constitutionally valid. And we should ignore them when we decide this matter.
We submit that there was perhaps an omission in the application, because this too would effectively fall in line with the others which should fall to the ground.
Thank you. Thanks.
Sorry, my lady. Yes, these provisions should also fall to the ground. And at the time, we are a new legal team, so to speak, coming in, but on a closer scrutiny of that, I agree with Milady. Thank you.
Thank you, Mr. Naidu. Sorry, Mr. Naidu.
Oh, I beg your pardon.
Mr. Naidu, we may be getting a bit ahead of ourselves, because before we can look at remedy, we need to be satisfied that a proper case was advanced and determined by the High Court with regard to the unconstitutionality of the provisions in question.
Yes,
You would accept as a starting point that your reliance on Section 30, 31, and 211, all those three provisions must be read on the basis that, firstly, the Constitution is supreme, and that's proclaimed in Section 2.
Yes.
Also, within each of those provisions, there is a recognition of customary law and traditional leadership subject to the Constitution. So,
Correct, yes.
so there's an interplay and an important conversation that must be held between customary law and the Constitution. And it's not an easy discussion. We've navigated that road with some difficulty,
Yes,
but it's unavoidable.
yes.
Now, the difficulty I have here is firstly, the expert, certainly in the High Court simply dealt with his evidence on the basis that his view was that this was what pure customary law was, and this is what must be preserved.
Yes,
There's no discussion in the High Court judgment with regard to the intersection between those features of customary law and the Constitution. So that's the first difficulty I have. The second difficulty is that the High Court, as my brother Justice Majid pointed out, applied the incorrect test. They applied the test of reasonableness that would apply to socioeconomic rights.
yes.
The state has just charged its obligation. You have attempted to argue that it's self-evident that this is a violation of customary law. But that's not good enough. In an exercise like this, the High Court should identify the provisions of the Constitution and which rights have been limited. It failed to do that. Secondly, having identified that, it must subject that to a limitations exercise. Whether the parties assist it or not doesn't really matter. This court has said that even if no justification is offered by any of the state respondents, the court must undertake a limitations inquiry.
Yes.
So that's all missing from the papers, from the arguments, and from the High Court judgment. So I'm in this awkward position that it's very difficult to make a determination whether there have been rights that have been violated, and if so, what the extent of the violation is. Because how can we declare something unconstitutional without accurately capturing what the extent of that unconstitutionality is? Because if we refer it back to the KZN legislature, they won't be any wiser with regard what is it that they're required to do. And that is being borne out by the debate in this court. Because you argue that, well, the Umdeni and Inkosi should be provided with they should be heard, they should be consulted. But then there's another view that, well, their role as decision maker must be restored and not just to be consulted. You yourself said you've changed your stance.
Yes.
So what kind of guidance must this court give? And therein lies a number of problems that I have. So I'd just like your view on that it makes making that determination all the more difficult.
I think
We can't make that determination on what the parties may agree upon. That's not, because how do we prevent some other litigation coming up next week and someone saying, well, you made this determination based on an agreement reached on the steps of the SCA, it's not binding on us. So these are some of the sort of formidable difficulties I'm having, Mr. Naidoo. Thank you.
Justice Collapin, the reason I have no difficulty in this and make the submissions as black and white is that the Constitution says the traditional customary rights and customary laws which have bound people and by which they have lived from time immemorial must be respected.
So, Mr. Naidoo, with respect, customary law is not static, it's also dynamic. It evolves over time. I mean, this court has had to deal with issues that recognize that particular phenomena. So it's just not a question of saying, well, if we found customary law as it was in 1870, then in 2026, the starting point must be that we must honor it. But at the same time, because one can't, in a different context, use culture to stand as a barrier to transforming our society. So that's the only point I'm saying, that it doesn't assume some kind of supremacy.
I'm not having how shall I say, an academic discussion. I am looking at this as a real discussion. We have a community there, which is the Matulini community. They're part of, shall we say, the Amazulu tribe or community, the traditional community. So if they are a traditional community, among the traditional communities, they don't have to theorize on what the law was in the 18th century or 16th century. They know among themselves what our customary law is in 2025, what our customary law is in 2026. It is not something esoteric or arcane for them. They know this is our customary law. And believe it or not, the concession made by the legislature, persons making the law, is one which they made after litigation before two judges, so to speak, and the third court, the SCA. All I'm saying is, this court is faced with a situation where it is not asked to determine what the customary law is. This court is asked to make a judgment in a scenario where the legislature and the community already know what the customary law is. Knowing that...
Sorry, Mr. Naidu.
Yes.
I accept all of that, but you're not answering my question. What is this court to say with regard to the extent of the unconstitutionality, for example? Is it to say that the Umdeni Inkosi must be consulted on removal, or is it saying that the MEC should have absolutely no power? That's not clear from the judgment of the High Court, and it's not clear from the submissions that we hear today.
We have the discussion of the impugned sections. We say, in discussing the impugned sections, it is necessary to posit them in proper context. To this end, we commence with a discussion on the provisions of Section 19. And we find that in Section 19, whenever the position of an Inkosi is to be filled, the Umdeni Wenkosi must, with due regard applicable customary law, and Section 3, identify a person in terms of customary law to assume the position. And it then says the Premier is then asked to appoint that individual. And the Premier must appoint the individual unless he has...
Mr. Naidu, with respect, I'm aware of that. My question was a more specific one.
Yes.
I'm still not sure what your position is with regard to what is the extent of the unconstitutionality.
The extent of the unconstitutionality we do mention is that in paragraph 5, from the aforegoing, it may be gathered that the Umdeni Wenkosi is indeed the sole and effective decision maker in the appointment of an Inkosi. We are saying the decisive voice in the appointment and the removal of an Inkosi is the Umdeni Wenkosi, not... Yeah.
So, thanks for answering that. So you're saying that any reference to government being involved in disciplining and removing a traditional leader would be unconstitutional?
Yes,
your position.
yes, yes.
Thank you. That's all I wanted to
Oh, sir. Thank you, thank you.
Mr. Naidu?
Sorry. If I may just add to that in regard to whether the judge deals with this, we find that interpretation of the law against the impugned provisions, the judge does have a discussion in regard to section 36 of the Constitution. In the record, that discussion, for convenience, we mentioned, spans page 615 through to 16.
Yes, I
Thank you,
see that, but that's where the incorrect test is adopted. Because at paragraph, at page 616, at paragraph
Yes.
52, the judge says they must be tested against the criteria of reasonableness. They will have to pass
Yes.
a rationality test, whereas that's not the test.
No, our position is as we reflected in paragraph 5 of our heads of argument. Thank you, Justice.
Mr. Naidu,
Yes.
can I just take you back a little bit to the question that Justice Mhlandla asked? I
Yes.
didn't quite get the response.
Yes.
Or your response to the question of the role that Umdeni seeks to play. At some instances in your papers, in the record, it's referred to as the right to participate, and in some instances, it's the decision-making right.
Yes.
Are you now sticking to decision-making right only?
Sorry, if I may explain the context. What I've been saying is that in the High Court and through to the Supreme Court of Appeal, and when the application itself was placed before the Constitutional Court, we as a legal team were not involved in that whole entire process. We were brought in as a new legal team later, and when we looked at the papers, we realized that the previous counsel, senior counsel, junior counsel for the applicants, looked at the position or the plinth upon which they placed their arguments and contentions were on the flawed legislation. In other words, they say, in terms of the legislation, these parts of the legislation say that the Umdeni Wenkosi should have been heard, but the Umdeni Wenkosi was not heard, and therefore it was unfair, because the Umdeni Wenkosi, in terms of the customary law, is the body which should be heard. When we came on board, we then drew the heads on the basis that the customary law, if properly represented in any statute, must repose the effective decision-making power in the hands of the Umdeni Wenkosi, not in the hands of administrative officials, not in the hands of the politicians.
So that case is made only in the heads?
That case is made in the heads, that is true. But what we say is, because of the relief sought, we seek no different relief.
Okay.
But we say that although made in the heads, it is supported by the material in the record before this court.
Okay, let me just understand this. On the case now
Yes.
made in the heads that
Yes.
your submissions hinge on,
Yes,
taking you back to Section 21.
yes,
Section 21(2) seems to recognize the role that Umdeni Wenkosi plays
yes,
in the removal
yes,
of the
Yes.
Inkosi.
Yes.
It says if Umdeni wants to remove the Inkosi, it must go to the Premier, it must set out the particulars and the reasons why it seeks to remove
Yes,
the Inkosi, right?
yes,
And then the section then later on says, even then, the procedure set out in section 23 is applicable,
yes,
even in the process started under section 21.
Yes.
Right. So it seems to me that there are two ways in which the process of removal, let's say the disciplinary process, for lack of a better way, it may be at the instance of Umdeni Wenkosi, and it may be at the instance of any other member of community, so to speak, as
No.
it happened here.
that is wrong. What we say is, in terms of these subsections, they say we recognize the Umdeni Wenkosi as the person who may appoint and remove. And at the same time, what they do is they take the whole entire power to the politicians.
So that's the backdoor argument that you
That's the backdoor argument, because
in
you
that
can't.
instance,
Yes.
what does Umdeni submit should happen? It should make this complaint to the Premier and again decide it.
No, the
What
Umdeni does not have to consult with the Premier. It doesn't have to consult with any administrative official, because it is the guardian, keeper, and the person who makes the final decision. If, for instance, one may talk about a...
So it should, if it is of the view that Inkosi should be removed,
Yes.
just remove him or her.
The Umdeni Wenkosi is the body that makes the decision to remove, not the Premier.
No, I'm asking the question.
Yes.
I'm trying to find out how this should be done procedurally.
The Umdeni Wenkosi will then inform the Inkosi, on these grounds, for these reasons, the Umdeni Wenkosi intends doing this, and give him an opportunity to say why.
And then,
Because,
after that,
and after that, remove the Inkosi.
okay.
And then if the Inkosi then...
So is there a challenge then to section 21.2? Which directs that Umdeni should inform the Premier and set out the reasons for the removal. Because I understood the challenge to be limited to section 21.4.
No, there's no challenge to section 21.2 for the reason that in the scheme, the Premier is not making any decision. He's not a decisive voice. It is the Umdeni Wenkosi which is now publishing its decision through the Premier. And the Premier acts in the sense of an auditor. The Premier then says, okay, you asked me to do this. I am the Premier, you asked me to do this. And the Premier then looks at what the Umdeni Wenkosi requires him to do and whether it has complied with customary law. Once he's...
But
Once he's...
ultimate decision maker will still be the Umdeni Wenkosi.
Correct, yes.
Can I just ask something else in relation to section, this whole scheme
Yes.
that ends at section 23.11. Section 23.11D
Yes,
says that the role of the Executive Council,
yes,
after the consideration of the report and everything,
yes,
if you look at D, okay, there's
yes.
formal written warning and all the others. But ultimately, what I think is relevant to our inquiry today is the notice withdrawing the recognition of that traditional leader.
Yes.
That is what Umdeni is objecting to.
No, in fact, if one has recourse to the relief which Umdeni seeks, one finds that the whole of Section 23 is to be revised.
Is what, sorry?
In the sections to be struck down, we ask for Section 23 as a whole to be struck down as well.
Yeah, I understand.
Because- yes.
But I mean, what the Executive Council,
Yes.
the act that the Executive Council performs
Yes.
is to withdraw the recognition. That's the ultimate act that will have
Yes.
effect.
But it withdraws
So
recognition.
what I want to ask, what is improper in the withdrawal of recognition resulting in the same state structure that recognizes the Inkosi in the first place?
The problem with this section is that the person who makes the decision in terms of 23 would not be the Umdeni Wenkosi.
I understand.
Yes.
That's what section 23,
Yes,
11 says.
yes,
It says, at the end of the day, after all processes have been undertaken, the Executive Council withdraws recognition. Because there would have been a certificate of recognition,
yes,
and now it takes the decision to withdraw it.
yes. And that is usually the appointment is done by the Premier and the withdrawal by the Premier, yes.
Yeah. So what is improper in that scheme of conduct, executive conduct?
In other words, is my lady asking, if the Umdeni makes the decision and then asks the Executive Council to publish the withdrawal, is there anything wrong in that? Is that the question I am to address?
I don't understand the question that you're asking.
I don't understand my lady's question.
Okay, I think let's just pass on, Mr.
Because my lady is taking this out of context of the scheme of Section 23, and I don't see it, and I must admit.
I'm not sure how. I mean, I said I understand.
Yes.
At the heart of your complaint
Yes,
is that the decision maker should be the Umdeni Wenkosi.
correct.
Right, okay.
And I've also gone further to say that if this court finds a solution which addresses that principal problem, and
Yeah.
even if the executive is to publish it, we have no problem with that.
Yeah, I understand that.
Yes.
I'm just trying to understand the case upon which the proposed remedy
Yes.
by the applicant is based.
Yes.
And then again, if I can go back to the question that Justice Mhlantla asked,
Yes.
to the role of the Umdeni. It seemed to me that the basis, at least on the heads,
Yes.
the basis on which Umdeni said it should make the decision partly is because it is the custodian of customary practices. Am I wrong?
That's partly yes.
Yeah.
And if
If that is the case, is the scheme of all these sections, or why is it unconstitutional in causing the Umdeni to participate in the actual complaint, at least as set out in section 21(2)?
yeah,
Because if I would imagine that the participation that is relevant, or the role that will be actually most valuable, is for the Umdeni to in the inquiry itself to set out what the limitations of the conduct complained of are, so that the decision maker from the beginning in the initial inquiry makes a properly informed decision.
That is exactly why it is the Umdeni Wenkosi which will formulate the complaint against the Inkosi and give the Inkosi an opportunity to address the Umdeni Wenkosi on whether he should be removed or not removed. Now, what happens in the legislation is the roles are reversed.
So the Umdeni doesn't anticipate that it will give evidence on the
If
customs which it is the guardian of, to inform the disciplinary process.
Let's use a different scenario. The Constitutional Court is itself the decision-making body. The Constitutional Court is assumed to know the law, know the principles applicable to the law, and is the person who says, I am making this particular decision. But happily, since the Umdeni Wenkosi is not at that level, if any party appearing before the Umdeni Wenkosi is not happy, that person would have the right of review to the courts. That's the first argument one would make. The second argument is this. If one takes the succession into account.
So who is going to set out the customs that are alleged by the complainants to have been transgressed before the disciplinary code, inquiry? The Umdeni
Yes,
has not...
yes. What one is doing now is this. One has the customary law. One now wants to take the customary law.
Well, there's a difference. Isn't there a difference between general customary law and customary practice practiced in a particular community?
Yes.
And isn't that what the Umdeni is the custodian of?
Yes.
That here in this community, this is how we do things. These are the customs.
Yes.
In relation to these complaints.
Yes.
Right.
And part and parcel of what is ascribed to the Umdeni Wenkosi is this. If one has for instance, the Umdeni Wenkosi is a community usually tied by blood, they're relatives, they belong to one clan, they have their customs, traditions, etc. The real question here is, with reference to the Matulini community, for instance. The Matulini community is a traditional community which owns vast areas of land.
Mr. Knight, I don't want us to eat upon the time of my other colleagues.
But what I have to say, my lady, is this.
My inquiry is to the exact role given exactly the expertise that you're trying to lay out
Yes.
of the Umdeni Wenkosi.
Yes. But
Because it seems to me that's what's anticipated
yeah.
in these sections.
Milady talks about the Umdeni Wenkosi sitting in judgment, as if it is sitting in judgment and is also the prosecutor. But in the correct scenario, when one has the Matulini community, for instance, and the reason for my going to certain of the facts that bind this community together is that that community owns the land, the assets, and that community, as in a company, is the community which would want to make the decisions pertaining to who rules it, on what basis it moves forward. And in this particular case, outsiders who are not part of the community, who are not best placed to protect the interests of the community, the future of the community, want to come in and have the decisive voice in who rules the community.
I hear
That
you.
is what the
Thanks, Mr. Chairman.
Constitution protects.
Tenaidu, this side. I'm sorry, I might be repeating this question.
Yes.
If you go to section 21(2)
Yes.
and you read it with section 21(1), my impression I get there is that in terms of subsection 2,
Yes.
Umdeni Wenkosi is able to decide on the removal of an Inkosi. Am I correct?
Yes. Yes.
And having done so, it would then have to advise the Premier and provide reasons.
Yes.
So it is, in fact, it has the decisive voice in relation to at least 5 of the grounds set out in section 21(1). Am I correct?
Yes.
The only aspect in relation to which its involvement is limited is the ground listed in 21(1)(f). Am I right?
Yes. Yes. That is an indirect way of saying you can deal with 1, 2, 3, 4, 5,
Yes.
but I have the power now to deal with 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. And I thereby usurp all the power of the Umdeni Wenkosi and am the decisive voice in the removal by virtue of the broad definition. And in the first place, why should one even have that decisive voice in the hands of this politician?
Let me just interrupt you for a moment.
Yes.
Then in relation to grounds listed in A, B, and C,
Yes.
the Premier will only give effect to that decision after having received representations from the affected traditional leader. You have no problem with that. It makes sense because that is meant to give him a right of hearing, or her.
No,
It's
the,
subsection 3. Or is my understanding, did I go astray there? Because all my reading of the scheme of the
Yes.
Act is that there are these 6 grounds.
yes.
5 of them are to be triggered by the decision by Umdeni Wenkosi, but in relation to A, B, and C, you must give the traditional leader affected the right of hearing. In relation to D, E, and F, let's leave F for one moment. In relation to D and E, that decision will not be given effect prior to it being subjected to an inquiry. What is problematic about that? Umdeni Wenkosi has decided to remove. It's based its decision on grounds D and E.
Yes.
Forwards that to the executive member concerned, but the Act is designed to give a fair process to the affected traditional leader, that it must go through an inquiry before it's given effect to. Is that constitutionally impermissible?
We say it is constitutionally impermissible because, because, as I've explained, the grounds upon which an inquiry can be called for by the Premier, by the MEC, are so wide that it encompasses everything in the entire section.
No, why do you
And-
say that?
and-
Because section 20, it's only section 23(1).
Before my Lord goes on, I was saying and, to complete my thought. And in the first place, why should the powers of the person who is appointed the judge in terms of customary law now vest in the hands of a politician. The Constitution says we respect customary law, and the customary law says the Umdeni Wenkosi is the decisive voice. That does not exclude the right to review, the right of the courts. Any person who wants to complain against the decision made by the Umdeni Wenkosi, which is the decision maker, has a right of recourse to the courts. What my Lord is saying is, you can now tamper with the customary law, change it, put it into a legislation, and we submit that that is wrong. And we submit in this particular matter, the person who did that, the legislature, also agrees that that is wrong and that these provisions should be struck off. I know we have said that this court is not bound by that concession, but we...
No, you don't have to go there, but I understood it to accept that in relation to the appointment, the executive plays what you named an auditing role, and you have no difficulty with that.
Yes, yes.
And now, what is contemplated in subsection 3 of 21 and subsection 4, excluding the misconduct referred to in subsection F? Why does that not qualify as some auditing of sorts before the decision by Umdeni Wenkosi is given effect to? Because it
21.1, you say 21.1F.
If you take 21.1F outside.
Is my Lord taking 21.1F and placing it outside and making it into an auditing role?
No, just work with me here.
I cannot work with anyone on that.
I'm trying to tease something with you.
Yes.
Because the appointment is not made, not given effect to by Umdeni Wenkosi. They come together,
Yes.
they nominate and decide, they pass that on to the executive to appoint. You have no difficulty with that.
Yes, it's
And the executive
merely,
must be satisfied.
it is a role which is, when you decide on something, you send something to the newspaper and say, look, print this to publish it to the people. The newspaper doesn't then come in and take a decisive role in anything.
All right.
And I know my Lord spoke about an auditing role. What is wrong with that? The auditing role here is much
You
more...
won't answer that, you must answer it in relation to your acceptance of that auditing role in relation to the appointment. If it's good for the appointment, it must be good for removal. That makes sense, doesn't it?
They are not in the... Let me put it like this. They occupy a role where they simply say, look, have you crossed your dotted your I's and crossed your T's? We find that maybe this may be a complaint. Have a look at it again. The decision-making body then is the Umdeni Wenkosi. Whereas in this case, they go to another administrative official who has the power to appoint someone else to have an inquiry and come with their own decisions and then act on that. So it's not an auditing role that is being played. And when I say auditing role, not in the a normal sense of an auditor, but merely to see, you've told me to publish it. Maybe this, that, or the other hasn't been done. I'm merely coming to advise you, to inform you that this is missing from what you're doing. And then the decision then is still in the hands of the Umdeni Wenkosi, not in the hands of the Premier.
All right, and then section 22, what's the problem there? Because it appears to be a consultative process that seeks to get some information from the traditional leader concerned. It's not, does
Well,
not
why
affect-
should the
Yeah.
Executive Council arrogate to itself whenever it deems fit to call a traditional leader before it?
Because there is cooperative governance, Mr. Naidu, isn't there? Because if you read that section, there are instances where it may be the executive that is required to do something out of that consultative process, and at times it may lead, of course, to an inquiry in terms of section 23. Why is that objectionable?
These are matters which concern the traditional community. The executive is an outsider who now wants to summon the Inkosi, the leader of the traditional community.
All right, and then
And then start giving commands, and it takes power away from the Umdeni Wenkosi and places it into the hands of an administrative official, a politician.
And then in relation to the only misconduct, which I think you can make a fair point that Umdeni Wenkosi is excluded, is the one that is set out in
Yes.
section 23(1). But that, on my reading of it, does not involve any breach of a customary rule or that sort of thing. It talks about the failure to comply with the provisions of the Act. Is that something that Umdeni Wenkosi is capable to enforce? It talks about the breach of the code of conduct.
Well, it's an opinion which can be held by a politician through which he can rule the traditional community. What we are saying is the persons who should be ruling the traditional community, the persons who should be the leaders of the traditional community, are not the politicians in Kochta
So
who
when
are
it's
given the
complaints-
power, who have arrogated to themselves in this legislation powers they don't have and powers they are not entitled to have in terms of the customary law. And when one reads this act, one sees that one is dealing with recognition of the community's culture, customs, and so on. And what is being done again through the back door.
So,
is to
for
use-
example, where there are allegations of abuse of power against affected traditional leader, and Umdeni Wenkosi does nothing. So that community must be helpless.
Why should
Because-
the politician be there? The police are there, the courts are there for these complaints. They are not the leaders of the community. In other words, the discussion foundation is all wrong. The foundation upon which my Lord is discussing the matter is, this is the legislation.
That seeks to hold accountable.
This
all those that
legislation is
exercise
a
power,
fraud.
isn't it?
This legislation is a fraud in the first place because it is supposed to enact the customary law which the community has observed from time immemorial. We need not go into the debate of what is the customary law, because we know what the customary law is in this case.
And then
Besides-
lastly, Mr. Naidu, regardless of the egregiousness nature of the misconduct that a traditional leader is accused of, he or she must just continue.
No, but
to show. About section 24(1), and that's my last question to you. So you say,
yes.
as long as the Umdeni Wenkosi does not suspend that leader, it's all good.
No, that is not what is happening here. That is not what we are about in this court. What we are about in this court is the premise upon which you're working is the legislature was entitled to write this law. if you find that the legislature was entitled to write this law in terms of the Constitution and the customary law, which it is supposed to be respecting, then your premise and foundation, that you can use that as your premise and foundation. But once we say in the first place, they shouldn't have had this premise and foundation for them to stand on and make judgments on the community, then this court is the one. That is why we have read on first principle. This court is there to say, you have made this legislation, you are not allowed to make this legislation, I'm sweeping it aside.
Thank you.
Thank you, Mr. Naidu. I just wanted to ask you about the national statute and the relationship between the national statute and this statute.
Yes,
This court considered that statute in Sikau
yes,
in relation to the removal
yes.
of a monarch. And that is the Traditional Leadership and Governance Framework Act of 41 of 2003. Now, in terms of that statute, the Premier appoints and removes a traditional leader from office. So if this court were to set aside this provincial statute, what would be the impact as far as that statute is concerned?
Milady, as far as I am aware, I think that statute has already been found not to be in line with the Constitution. And what we say is this.
In which matter is that? You're saying it's no longer...
The National Act of 2019.
I was speaking of the... Are you saying that statute's been set aside by this court?
Milady, I understand that that act has also been set aside. In other words, it has been...
In which matter is that? And was it referred back to Parliament or was it set aside?
Sorry, my lady. Milady, I know that the National Act, that is the 2003 Act, is one which has been replaced by the National Act itself. And Milady, my answer to Milady would be this. The provincial legislature itself is, in its own right, a legislation-making body. And as a complete legislation-making body, it is subject to the Constitution.
Let's look at the national statute, because the national statute that you say is set aside provided, expressly stated that the provinces were entitled to pass legislation, but it provided a framework within which that would occur. So if you're saying it's replaced by a statute, then perhaps we must deal with that statute, because it provides the framework then under which the provincial statute must be considered.
Milady, I beg my lady's pardon, but I understood that the National Act was also under, in the process of being amended, but I would not press that right now. But what I would say is this, that in terms of the Constitution, the provincial legislature as a legislation-making body in its own right must comply with the provisions of the Constitution we have mentioned. And therefore, whatever the National Act framework is, the legislation made by the provincial legislature is as a whole itself subject to the supremacy of the Constitution and directions of this court.
Mr. Naidu, my further question relates to appointment and removal. In Masetla, in the context of executive action, this court decided that where the president has a power to appoint, the president also has the power to remove.
Yes.
In relation to Sitkau and consideration of that statute, a similar decision was made. In this statute, the Premier has the power to appoint, and as some of my colleagues have canvassed with you,
No, milady.
to recognize appointment.
No, milady. In this particular statute, as enacted by the legislature, the Premier does not have the decisive voice in appointing any individual.
But he takes the recommendation of Umdeni, Wenkosi, and
Yes.
he then considers it, and if he's not happy with it, sends it, under certain circumstances, for instance, may send it to the House of Traditional Leaders.
Yes, that is why in...
But my point ultimately is that the final signature on a piece of paper to say that Inkosi is appointed is that of the Premier. The appointment is ultimately that which is signed off by the Premier.
Suppose the Premier says, I'm not going to sign. Then the Umdeni Wenkosi has the power to go to a court and tell the court, I, the Umdeni Wenkosi, am the bearer of the power reposes in me. In terms of the scheme of the Act, if the Premier has a suggestion to make, then he must make it to me. I must consider his, in other words, it's a consultancy, a right to be consulted, so to speak, not a decisive right to do or not do. If he says, I have a problem with this, the Umdeni Wenkosi then considers that. And then when it returns it to the Premier, the Act says the Premier must appoint, not that the Premier may appoint. So, through the legislation itself, in the 2005 Act, the Premier does not have a decisive voice.
So if I understand you, you're distinguishing between appointment and recognition, because the Act provides for the Premier to recognize the traditional leader.
My lady, in the context, what do the words appoint and the word recognize mean? They merely say, you come in here, I recognize you. But it's not, I am the decision maker on whether I recognize you as an Inkosi or not. The decision maker as to whether I recognize you as the Inkosi or not is the Umdeni Wenkosi. And that is why one finds that we have underlined the words must in paragraph 2 and 3 and paragraph 4 of our heads of argument, because it doesn't leave a discretion reposing in the hands of the Premier. There's no discretion. He must do what the Umdeni Wenkosi says he must do. Well, one can postulate a scenario where he is adamant he's not going to bring a signature. Then if he does that, then the court or someone else would have to determine that. But that is not what the Act envisages.
Well, the Act envisages in section 19(4) that where there's evidence of a person having been identified who is in a manner which is not in accordance with customary law, customs or processes, then the matter may be referred to the House of Traditional Leaders, for example. So there are other avenues available.
Yes, yes, he may lead, but the decision-making power doesn't then transfer to the House of Traditional Leaders. It doesn't, it then goes back to say, if it is referred there, then they may be consulted, and ultimately the power reposes in the hands of the Umdeni Wenkosi. That is what we submit.
May I just follow up then finally on the questions that were posed to you by Justice Collopin and Justice Nuku relating to the balance and the interaction between the Constitution and customary law?
Yes.
And the complicated areas and have posed
Yes.
difficulties and have been considered in different matters. But in the context of Section 30, 31(2), that the rights set out in 31 of the Constitution may not be exercised in a manner inconsistent with any provision of the Bill of Rights. How then are we giving effect to that if your answer to Justice Nuku was that where a member of the community might feel, for instance, there's been misconduct, that their remedy is to either to approach the courts or SAPS, that there's no other remedy available to that member? Are we giving effect to Section 31 and the concern that it needs to be interpreted in line with provisions of the Bill of Rights?
Well, lady, I was answering off the cuff in the sense that if the judge is the person who has to make the decision, and I write a rule book in terms of which I say, in this particular matter, counsel shall tell the judge what decision to make. That writing is flawed, is not correct. That is what we're saying. What we're saying is, you cannot, as a legislature, go and say, whilst the judge has the decisive power, I am transferring the decisive power to the advocate to direct what is to be done. To use a crude example.
Thank you, Mr. Naidu.
And just to extend this a little further, when one is talking about a traditional community, a certain measure of understanding of that milieu has to feed into the interstices of what we're dealing with. At heart, one finds it's not just a community, it's a clan, so to speak, a traditional community, previously a tribe, so to speak. So what happens is they are all in that community. There are relationships built, there is knowledge built, and there are measures of protection. And that is why the Constitution says respect that. What this legislation is doing is bringing non-family members, non-community members, so to speak, to make far-reaching decisions impacting on this community.
Well,
And-
understand in your answer about
Yes.
SAPS and that how then is, for instance, a traditional, how is the traditional leader then kept accountable, for instance, in circumstances where there is misconduct by members who are not part of Umdeni, Wenkosi? How are they kept accountable?
Well, lady, the Umdeni Wenkosi is a body of persons with knowledge, a body of persons who have the trust, so to speak, of the community as a whole. If a complaint is taken to the Umdeni Wenkosi pertaining to the Inkosi, the Umdeni Wenkosi would have to seriously consider that. And that is why the Act, insofar as it mirrors the traditional law, then says the Umdeni Wenkosi may then bring up charges for removal of an Inkosi. So there is this process.
Thank you.
Mr. Naidu,
Yes.
perhaps I should just try to explain how I understand the process.
Yes.
You've been trying to explain it, maybe because you haven't lived in that area. What normally happens is the Umdeni Wenkosi consists of the senior elders of the
Yes.
If, for example, a chief or a leader were to be found to be wanting for any other reason, those elders of the community, or if a report is laid, the report would be laid to those elders of the community. And it is those elders of the community, the Matulwini community in this instance, that would take appropriate steps against the errant chief or leader.
Yes.
That's how the customary setting works, not any other way. And your case is that if there was a complaint against the levies or the tributes that the king or the chief or the leader levied, right?
Yes.
The proper forum should have been to that community, and that community would have decided whether these levies accords with custom or not.
Yes.
In this case, we are told that a group of about 100 people signed a petition, and as a result of that petition, the investigation was triggered. Properly so, what ought to have happened, if I understand your argument correctly, would have been for the premier or the MEC then to say, this complaint about the internal ructions in the community should or ought to be decided or dealt with by that community.
Yes.
And once that community has dealt with it, then it can go through the processes and be escalated to the premier, short of taking the, for lack of better word, the shortcut and preferring misconduct charges against the chief.
Yes.
Is that what your case is all about? Or
It also goes further. My Lord has indicated that a petition is gathered. Now, if you have, for instance, a petition,
in my village, let me tell you, in my village, if the king, let me not be punished, if the king or the chief is misbehaving, for whatever reason, the elders,
yes,
and I think it's in the all village, the elders of the community would come together and say, the king has now gone rogue, or
Yes.
the chief has gone rogue.
yes,
And what do we do? And that body, it's called Umdeni.
Yes.
Wenkosi. It means the house of the chief. It's not one person.
yes,
It's
yes.
that body. And it is that body that would decide what to do with that chief.
Correct. Yes.
And once it does that, then it would trigger section 21(2).
Yes.
Right? And for it to be triggered, there has to be a referral by the Umdeni Wenkosi
Yes.
to the premier. And what the premier would do, and there will be reasons why this is the position. And then the whole process gets triggered out. Is that not
Yes.
what this is all about?
Sorry. With respect, I don't claim to have, how shall I say?
Well, you can bow to my superior knowledge.
I've said, not speaking as an expert, I accept that that is precisely the milieu, the culture I was talking about that one must understand. And in this particular case, even if you have a petition by 1,000 non-members of the community, it doesn't help you because it is a matter concerning the community. And it would be community members, if they were to petition and complain to the Umdeni Wenkosi, then we are in the right ballpark, so to speak. So I agree with what Lord is saying.
Let's put aside what the amicus may have put before this court. You would agree with me that that does not preclude us as a court to bring to bear our conclusions and our opinion as far as this legislation concerns, invoking our section 172 powers. We can do that.
Yes.
Notwithstanding
yes.
what you agreed upon at the SCA or not.
No, that
Or
was
any other-
my point of departure. This court is not bound by the application or the applicant's agreement and so on. It has to itself, although it is the Supreme Court, so to speak, the court too is subject to the Constitution. And if the court finds that this is not in line with the Constitution, this court has the power to strike such legislation down, yes.
Now, if we were to undertake the exercise of a reading in.
Yes.
Have you thought of how that reading in should take shape?
I would confess that I have not thought about that aspect, because when we came into the matter, we found there that the parties had agreed to,
No, but we now know
yes,
that the heads
From-
of the amicus were filed on Friday.
yes,
We all had to read the heads of the amicus, and the suggestion is made by the amicus that
yeah,
we should save this section from constitutional invalidity by reading in. And the reading in would be the reading in that caters for the concerns that you've raised since
Yes.
this morning.
If I understand reading in, for instance, to be, as Justice Mashlantla has said, in this sub-paragraph, if we remove the MEC and replace it with the Umdeni Wenkosi, would you have a problem with that?
Well,
Then we,
perhaps you'd look at it, maybe in reply you could propose something for our consideration.
yes. And what I wanted to go to, if I may, is that in our heads of argument, if I may, at paragraph 21, the 2003 Act was repealed by the Traditional and Khoisan's Leadership Act of 2019, which was declared unconstitutional and invalid for want of compliance with the consultative process. I think what is this reference is to Milady, the fact that this is where the 2019 National Act was dealt with and found to be wanting. Thank you, Milady.
Thank you.
Thank you.
Okay, thank you, Mr. Naidu. We're going to take our break now for 20 minutes and come back. Court adjourns.
Oh, we're going to think of alternatives.
Mr. Mujapilo, I know I said 30 minutes. We usually don't give amicus that much, but I'm not retracting. I'm just mentioning that.
Yes,
Yeah.
hopefully I'll be quick and we'll be home by lunch. Deputy Chief Justice and the Justices of the Constitutional Court, we thank you for the opportunity to address you on this matter. We stand in a very unique position that we are not a party. As a result, we don't move for an order, or we are not opposing. We are in a unique position that we are amicus, and we have submitted heads, we have dealt with the judgment, and we have dealt with the principle as far as we can carry them. The theme of our heads, and that will be the theme of our submissions, will be that customary law is law. And I don't have to repeat it in this court, because this court has already made it in black and white that it is law, it has to be respected, it has to be applied. The institution of traditional leadership has to be respected, has to be given a proper space, and that is what our heads of arguments are saying. And my learned colleague has already given you some of the paragraphs. That's where we are. The Constitution happened. We are living in a constitutional supremacy. The Constitution came, and in Section 211 that we are dealing with currently, recognizes customary law. And it says what is important, that it's subject to the Constitution. Of course, it's repeating the constitutional supremacy. And it further says that the application of customary law, or maybe let me just read it. A traditional authority that observes a system of customary law may function subject to any applicable legislations and custom, which includes amendment to repeal of that legislations or those customs. So our submission will be customary law, subject to the Constitution, and in the current matter, subject to the Kwazulu-Natal Act. What does the Kwazulu-Natal Act do? And Section 19 is very important, although it's not in the one that is being challenged. It talks about recognition. And this word recognition, it's very important because the word appoint is being used interchangeably with recognition. I'm not going to read it as a whole, but Section 19 says the Umdeni Wenkosi identifies. And after identifying, they make submissions to the Premier, that is 1913. They provide the Premier with reasons for their identification. It can only mean that the Premier is going to exercise his mind to those reasons. And then subsection 3, the one that my learned colleague read, says the Premier must, subject to subsection 3 and section 3 and subsection 3, recognize a person so identified in terms of 1A as an Inkosi. So the Premier is still in terms of the Act of the KwaZulu-Natal Parliament, a player. He must still play a role in as far as the recognition of an Inkosi is concerned. So the royal family identify, the Premier recognizes. Now, the problem becomes now when the Premier, the applicant's case is that the Premier or the politicians, that's the word that is being used, should not be given the power. They are usurping the power of the traditional, of the Umdeni to appoint the chief. Of course, this comes from the evidence that was led, the expert evidence. My learned colleague has already taken the court to the report which is on record, the paragraph 8.5, where the expert says, I'm going to read the last sentence, paragraph 8.5 on 257. Under the senior members of Umdeni Wenkosi, the council had the final voice and the right to appoint, discipline, and remove the chief. One cannot argue with this law. It's a customary law. But we all have been told by the jurisprudence of this court that customary law is not static and is subject to the Constitution. And here is where we are. The Constitution, I have already started there. So our role today is to make submissions, to state to this court that the challenged provision or the order of invalidity cannot be confirmed because the challenged provisions can be constitutionally applied. The record of the proceedings in this matter, which is the subject of today, in our submission reflect a defect of application. It doesn't, to our submission, reflect the problem with the legislation. It's how the legislation was applied. And we submitted that unconstitutional application or unlawful application or irregular application of the prevailing statute can be cured in a review court under legality or any form of review, but not by striking down the provisions. This court, in the first place, must still exercise its discretion in terms of Section 172, despite the agreement that was reached by the involved parties here at the SCA. It must still ask itself whether the applicant has today made out a case that the legislation that is challenged is unconstitutional. And we submit it is not. This court must ask itself whether the text that is being complained of is capable of constitutional conduct. Can this court read it? Can this court interpret it to make it constitutional? And we submit that these challenge provisions can only be invalid if the text compels unconstitutional conduct, if the structure necessarily excludes constitutional compliance, or they are incapable of being interpreted consistently with the Constitution. And we submit that it is not enough that the provision can be applied unlawfully. There might be a complaint that they were applied unlawfully. We are not dealing with the merits of that case. The triggers we submit will be the legality or the rationality review. So an application of a wrong application of the law is not a proof that the law is unconstitutional. And this is what also the High Court found. We have dealt extensively with what the High Court found in our heads. But in our reading of the High Court judgment, properly read, the High Court judgment in our submission does not say the text prohibits the involvements of Umdeni. The High Court identifies the failures to engage the living customary law with appropriate method, of course, the evidence of the living customary law in terms of the record appears to be lacking in that hearing or that investigation. The High Court has also identified insufficient engagement of Umdeni Wenkosi where customary law mattered. And it has also identified deficiencies in rational and informed decision makings. But we submit that those deficiencies that were identified by the High Court appears in High Courts almost every day in the legality and the rationality courts. But what critically the High Court identified, and it gave a test that can this legislation be constitutionally compliant? Can the statute be read to be constitutionally compliant? After giving itself those options, surprisingly, the High Court did not follow that to test whether, if the problem is the exclusion of the Umdeni, can this legislation be read to include the Umdeni? And we submit that had it gone to that exercise, it would have reached a conclusion that these provisions are not unconstitutional. And that, we submit, is fatal to the confirmation application. If they can be read to be in conformity with the Constitution, the confirmation proceedings should fail. The first challenge section, that is 21 in brackets 4, the grounds for removal. We submit that it properly enumerates the grounds, but what it does not do, it does not prohibit consultation with the Umdeni. It does not direct the executive to ignore customary institutions. This court has said that customary law must be applied where applicable. And it does not define customary norms and laws in a way that displaces the living law. And also, one of the most important methods of customary law, the evidentiary methods. This provision is silent there. But we submit that the fact that it does not prescribe the method of bringing in evidence to prove customary law does not make it unconstitutional. Jurisprudence, our constitutional jurisprudence tells us that if decisions are going to be made that affect a certain grouping or individuals, they ought to be given a hearing. And if, in this case, the issue is customary law, the decision maker ought to be satisfied that proper evidence of customary has been, the proper evidence has been laid. That, with respect, we submit cannot be, the fact that the act is silent on that part cannot be a ground for unconstitutionality. We submit that where removal turns on the living custom norms, constitutional method supplies the discipline, customary law must be properly ascertained. And there is nothing in this section 21.4 that makes that constitutional requirement impermissible. The other two sections that are challenged are section 22 and 23, the suspension and inquiry mechanism. Again, in our submission is that this only creates procedural mechanism, and they also provide oversight, that is executive oversight. However, they do not assign to the executive the power to define customary law, nor do they bar evidence from a legitimate customary institution. I've already made submission that if that evidence is lacking, the decision that is arrived might be challenged. But nothing, there is no, the reading of this section does not exclude that evidence to be adduced. And then the last one that is being challenged is section 24.1, which is the consequences of an unlawful removal. This we submit is just a consequential and derivative result of what would have happened. So the fact of the matter is, at the end of the day, the legislature has decided to put at the end of this decision-making process the politician, in my learned colleague's word, the executive. They, in terms of the national legislation, what we can only see in terms of the national legislation, that is the one is commonly known as the Khoisan Act, is in terms of section 9 that all the royal house can do is to make recommendations. The final decision is with the state, and we have make submission that that protects accountability. All they can do is make a recommendation after any, whatever submissions they receive from the investigator or from the premier. So we submit that on proper reading of the judgment, which we have dealt with, and I need not repeat the wrong test that was applied, as the court has already taken my colleague on that. That is the crude bomb test, which was wrongly applied here. There is absolutely, in our view, no justification to set aside the impunged provisions as being unconstitutional. Jurisprudence tells us that if there is a constitutionally acceptable interpretation, that should be preferred. And we submit that the exclusion of the Umdeni Wenkosi is not a constitutionally acceptable interpretation, and it should not be the interpretation that is preferred to this section. There is absolutely no way these impunged sections are prohibiting that participation. Having said that, we now come, and that is our first prize, for a lack of a better word, that in as much as we are not opposing the Umdeni in this matter, in as much as we submit that we respect their role and our heads are replete, we submit that their role as custodian of the customary knowledge should play a higher role than the role before this type of decisions are made. But we submit that on these facts, on the facts of this case and on the interpretation of the impunged section, we found no reason at all to support the confirmation of invalidity. Of course, we also offer and argue what we say is an alternative, and that has occupied this court for a considerable amount of time. And I know that my colleague has been given a task to see what he can jot down in terms of whether the court can consider an interpretative remedy, which we just identified the reading in, meaning somewhere, somehow, this court should insert the words that both parties will submit that will make the section constitutional. Of course, that is as an alternative remedy. Our main remedy is that as it is, there is nothing that stops the interpretation to include the Umdeni. The final decision is with the executive. Yes, before I finalize, the word or the words or the submissions, that also forms part of the debate when we argue about what role must the Umdeni play. It's always decisive. They must play decisive. But we are not going to submit that they should be part of the decision maker. Because as the legislation has put it, the final decision maker is the state. And those are our submissions. We still have time.
Thank you very much, Mr. Mujapilu. I think when you started, you mentioned the role of the Umdeni Wenkosi in terms of identifying. And then that identified candidate is then given to the Premier to be recognized. Am I correct?
Yes.
Now, when it comes to removal, maybe one should start with, when it comes to discipline, and I think the section concerned here is section 23. One sees no role whatsoever for the Umdeni Wenkosi. That is, I would call it the traditional authority. I mean, if whatever has been reported to the Premier or the Executive Council could lead to removal, does it not make sense for the Umdeni Wenkosi, for traditional authority, to be involved at that stage? I'm just asking.
Yes. When there is an inquiry or an investigation, like the one that is passed, Umdeni Wenkosi should, in our submission, play a significant role.
But we have a section here that does not mention them whatsoever.
The section does not mention them, and our submission is that the interpretation should not be that they are excluded.
Yes.
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 The decision that will be made without, firstly, it is that issue of the proper identification of the customary principles that are applicable for that particular nation or that particular region. They definitely will need the evidence which we submit. The Umdeni will be very much instrumental.
Yeah.
But their exclusion in this section, or the omission of their way, does not necessarily, in our submission, culminate to that they are excluded. If that decision can be challenged.
Okay. So, just as the role they play in terms of identification, they identify, and I suppose, using my own language, they would then recommend to the Premier to say recognized. And once that person is recognized, that person is Inkosi.
Yes.
So when it comes to the other side of the coin, it would also be a recommendation, isn't it? They can't do the removal themselves, can they?
Yes, Section 9 of the National Act uses the word recommendation. Yes.
Okay. Thank you very much. Questions?
Mr. Mjapil,
As may please you.
lost a bit. My confusion arises from the fact that You contend that because there's an omission does not necessarily mean that the Umdeni is excluded. Let me take it a step forward. If we are to write a judgment as we're supposed to, what must we say in the judgment? Do you understand my difficulty?
I do. It is, my submission will be that the court will be dealing with an interpretative exercise, that can we interpret this section to say the Umdeni is excluded? Just because we don't read them there, but they are an interested party in this type of decisions. Just the mere fact that they are not mentioned there, can the court interpret it to say the statute, the design of the statute was to exclude them? If that is the interpretation that the court will finally reach, that will, in our view, result in an unconstitutional result. But we submit that the court ought to read it in such a way that the Umdeni is not excluded.
But what would be those aids in interpretation that would drive us to that conclusion that the omission does not mean exclusion? What are we going to be looking for? Remember, you are now inviting us to engage in an interpretative exercise.
Yes.
And now for us to say that omission does not mean exclusion, what are we going to draw from?
There are just two sections there. The section that the DCJ has referred me, that is section 23. Most of the offenses there would, in my view, in my submission, not need any evidence or knowledge of customary law. When the Premier is going to take a decision where the knowledge, I'm just giving this as an example, and the existence of customary law is necessary, and the Premier and the Executive Council takes a decision in ignorance of their participation, in ignorance of their submissions, that can be set aside in terms of a review. And we submit that is not a ground for setting aside the section as unconstitutional.
I'm lost. The more you argue, the more, and the deeper I go into the woods. I must confess, if I don't understand, I don't want to leave you under the impression that I understand you.
Let me just give it another go. The interpretative exercise that we are...
Sorry here.
Yes.
It says on section 23(1)(a), where there is a reason to believe that a traditional officer is guilty of misconduct in that he or she fails or refuses to comply with the provision of this act, fine, or any other law which it is his or her duty to comply, has breached a code of conduct. What code of conduct is this?
This I suspect will be the code of conduct for traditional leaders that will be published by the executive.
And G says, this is where we are, abuses his or her powers, or extorts, or by use of compulsion or arbitrary means, obtains any tribute, fee, reward, or gift. Is it not G located in the facts of this case?
G is definitely located in the facts of this case. Hence, I know Justice Matopo says he's lost. Let me try and see if I cannot unlose you. It's in a normal administrative inquiry, administrative law review inquiry, one of the consideration will be the decision maker, were they properly equipped? Did they allow relevant evidence? Was there evidence of Umdeni relevant for that particular inquiry? If it was, and failure to take it into account would be a reviewable irregularities. Hence, I'm saying the fact that there is an omission to Umdeni does not necessarily mean that they are required, does not necessarily mean that the interpretation should be that they are excluded. They are not excluded.
All right, I leave it to my colleagues.
Thank you. Mr. Majapelo, one of the problems with interpretation is that the court can't interpret legislation to reach an outcome that it would like to reach. The interpretation that the court arrives at must be one that is reasonable, capable, having regard to the text, the context, and the purpose, and you know that. The difficulty I have with your argument that says that we should interpret Section 23, is it?
In fact, the argument goes to all the section because that appears to be the substratum of the complaint, is that they are excluded.
That we should say that the exclusion does not close the door to interpreting it to mean that they can be included. The difficulty with that is twofold. One is that the structure of the Act itself, Section 19 is quite comprehensive in including both the recognition of the Umdeni Inkosi and their specific role. So the obvious question would arise, well, if the legislature thought fit to provide for quite detailed mechanisms with regard to the inclusion, why should we, when they excluded, adopt the same? Because the argument would be, well, surely then the legislature should have done the same 3 sections later. And the second point is simply that in the interpretation of the Act, I wouldn't think that would have been reasonable, because when the disciplinary inquiry was convened, for example, by the Luthuli attorneys, it didn't think that it was necessary to include Umdeni Inkosi in any way. So that's the problem. That one would have to find that its absence from the Act meant that it wasn't. Whether that is unconstitutional or not is another matter. And I've raised those issues with Mr. Naidu with regard to the unsatisfactory way in which that's been dealt with thus far. Yeah. But yeah.
Yes, the last part of the question from Justice Kolapen deals with the complaint that we will classify as a reviewable complaint. Lack of knowledge, non-participation. The difference with Section 19 is that before the Premier comes in, somebody must identify an incumbent. That incumbent is now a traditional leader regulated by statute. And if they fall into a conduct that we submit with respect that the legislation should be read to such an extent that where the role of the traditional leader, which is relevant for the particular facts, then they must be involved. It must be interpreted that they should be involved.
But I think it's much more than simply tweaking words here and there, because as I understand it, the structure of the Act provides that the executive may independently institute proceedings. And if they independently do so, then you say we must interpret that to mean that they involve Umdeni Inkosi. That's quite a different power than under 19, because 19 is they initiate the identification. Executive then acts on it. But in terms of removal, the executive can initiate processes, irrespective of whether, even if they come there and say, sorry, we're opposed to this, they can be consulted, but the executive can make the decision. So therein lies the difference. But I think
yes,
that this creates a difficulty with reading in.
Yes, that report and the recommendation to remove the chief should in our submission, in order for it to pass the Paja grounds, it must be at least, at minimum, be taken to the Umdeni for comments.
Okay,
That is,
thank you.
as the court pleases.
Mr. Mchapelo, I think we're all grappling with the same issues, particularly around reading in. But my view was that normally in an inquiry, I couldn't think of an inquiry or even in trials where there is a stipulation in legislation that if we are agreeing that the problem is that of implementation, that evidence should be sought from specified witnesses. Normally, reference is made to interested parties. And I tried to look at the regulations as to whether there's some guidance as to whether what the chairman, how he should or she should go about ensuring that interested parties are invited to the inquiry so that their input can be obtained. My concern with stipulating Umdeni, in particular into, say, Section 23, is that it seems to me from the definition of the parties, the various entities that are regarded as interested parties in the Act, Umdeni is not the only one. That is the custodian and also, say, custodian of the customs of a particular community or this community anticipated here. There's the traditional community, there's the traditional council, there's the royal family, and then there's Umdeni. All of them are defined in the Act. And in the earlier sections of the Act, they play a specific role with regard to regulation of community customs and mores. Now, if we elevate Umdeni as particularly an entity that must be consulted, what about traditional council? What about the others that I've referred to?
Yes, I think that is the stance that is our basic stance in our submission, that hence we say a remedy that is located in Paja cannot result in a statute being declared unconstitutional, because rarely would you find a statute that prescribes the steps. The statute will just give a power to a board or a decision maker to make a decision. But it's then, when that decision is made, then we know that there are these interested parties that were not consulted, there is this relevant evidence that was ignored, and hence our submission that it cannot be, as it is, read to exclude Umdeni.
Okay. And then, can you just clarify for me something in your heads at paragraphs 40 and 41? Because it seemed to me that the suggestion is that you say the record demonstrates that the mischief lies primarily in the manner of application and in the failure to constitutionally channel decision-making back to the Umdeni Wenkosi, where issues of customary misconduct arise, which seems now to go back to the applicant's argument that Umdeni should be the decision maker. Is that what you're saying?
Yes, if it is a relevant, not a decision maker, not a decision, did we say decision maker?
You say, no, well, I don't know what it means, but you say failure to constitutionally channel decision-making back to Umdeni Wenkosi, where issues of customary misconduct arise.
Yes.
So what, I couldn't quite understand.
Yes, no, yeah, the reading of this paragraph seems like we've elevated it to a decision-making. It can't be decision-making. It was supposed to be a participant, a relevant participant.
Okay, thank you.
Mr. Mchapi, you've argued that we should interpret the provisions of the Act in a manner consistent with the Constitution. Am I correct?
Yes.
Can you just make an example with just one of these sections that we're dealing with, how we should do that, or what we should read in? And just to make an example so that I understand.
Yes, the difficult part is the last one, the reading in. We are still grappling with that.
Which one?
What Justice has now asked me to read in.
Yes.
Yes. The basic submission that we submit is that the interpretation should not be to exclude.
Yes, I would like, remember we're going to write the judgment. Suppose we follow you and we are with you on what you're saying. I'm just asking you to assist me specifically how that provision should read, how we should interpret it, and what we should read in. I'm not sure about the terms of what we should read in order for it to be constitutionally compliant.
Just that there are two questions there. It is not, I'm not going to be able for now to deal with the reading in as was in the National Coalition case. That is where you add the words. What I am going to submit, and I hope I am, is that when one reads, for an example, an inquiry into a misconduct,
see, my problem, perhaps it's not a problem at all. You'll give me guidance on this. My problem is that if we say that these provisions can be read in a constitutionally compliant manner, do we just end there and not say they can be read in this way and then we write how they should be read?
yes, the first price will be to leave them as they are.
And
But-
say,
I beg your pardon?
and say,
And say the reading that includes or that does not specifically excludes the Umdeni is the one that should be preferred.
yes, but what is that reading? Because we have to say that they can be read in this manner, or we shouldn't just leave it at that. To say it can be read that way and not say, illustrate how it should be read.
Yes, I think Justice Chiti is asking me to dictate the word the reading in. We're still grappling with those words.
When
All-
I was asking you to propose,
Yes, we did propose, and all in our debate, the best that we could come out with was that there should be a meaningful involvement of the Umdeni.
how? Decision-making, appointment, or when Inkosi is being relieved? How should they be involved?
I think
Should they be consulted? Should they be part of the decision?
in our submission, they should be consulted. They can present evidence, not as decision makers, but as participants.
Okay, thank you.
Yes. I don't know whether I will open up other cans. In that Langa judgment, which is not in our heads, also dealing with traditional leadership of Limpopo,
Oh, yes.
oh, I've got an answer here from my colleague.
Okay.
For the question
Before
that,
you deal with that, let's just, housekeeping things. When you refer to Chief Justice Langa, you just said the Langa judgment.
oh, no, it's the party, the applicant was David Langa versus the Premier of Limpopo.
Okay,
Yes,
all right, thank you.
yes. I'm not going there because my learned colleague says I must read in answer to your question. I'm going to read it as it is. It is declared that Section 21 of the KwaZulu Traditional Leadership and Governance Act 5 is unconstitutional and invalid to the extent that it is inconsistent with Section 9 of the Traditional Khoisan Act 3 of 2019 in that it permits the removal or the withdrawal of the recognition of Inkosi without the decisive involvement of the Umdeni Wenkosi, the royal family, as the primary customary authority in the removal decision.
In that matter, I'm hearing you reading that it is declared unconstitutional, and I thought that you were saying in this matter, we should not go there at all. We should find that it's constitutional because it's capable of being read in a constitutionally compliant manner.
Yes, yeah, it is what the courts will say, a dissenting judgment. Our main submission is that this court should find that there's no problem of unconstitutionality with the challenged sections.
Thank you for that. I'm still grappling with how, for the basis for saying that. It would help if we would say that for these reasons, it can be read constitutionally, and therefore it should be read
Yes.
in a manner like this.
Yes, from what I've read, which is long, it refers to Section 9 of the National Act. And the involvement in Section 9, it's usually in terms of a recommendation. So their involvement is just to participate, provide evidence of customary law and customary practices, but to read these impunged provisions to say they are excluded, we submit that that should not be the preferred interpretation.
Thanks, Mr. Mchapelo. Thank you, DCJ.
As the please.
Mr. Mchapelo, this way. If the complaint is that there are certain provisions of the Act that have excluded the participation of Umdeni Wenkosi in removal proceedings, those would be Section 23(1) in respect of that misconduct, and that would also be in respect of suspension in 24(1). I'm not sure if I have the correct Act because sometimes I hear reference to 24 as something else. But on the statute that I have, 24(1) relates to suspension. It seems to me that the suspension as well as removal that follows the misconduct contemplated in Section 23 can be initiated by the executive without any reference to Umdeni Wenkosi. Isn't that a fair point?
Yes, I think it's the question that is intertwined with what Justice Matopo has showed me. And our submission is that
but before you make submission, I just want to make sure that is my understanding correct, My reading of section 24(1) is that suspension may occur without reference to Umdeni Wenkosi, and that removal proceedings may be commenced under section 23 in relation to the misconduct dealt with in section 23(1) without reference to Umdeni Wenkosi.
Yes, the inquiry, yes, and the suspension.
So that complaint would be a legitimate complaint to say that they've been given no role at all to play in those proceedings.
As I understood the question was the initiation.
Okay, let me,
Yes,
let me,
but during,
if you
I
look
beg your pardon.
at section 21(1), there's 6 grounds of removal. A to E may be initiated by Umdeni Wenkosi. I have no difficulty with that, they have a role to play there. But F relates to misconduct contemplated in section 23. And that is the one that where you go to section 23 can be initiated without any on my readings. That's what I'm testing with, if my reading is correct.
Yes, it can. That's the reading, yes.
So I think what we are struggling with is how do we then interpret those two provisions in a manner that would be constitutionally compliant as regarding the exclusion or inclusion of Umdeni Wenkosi. We just need your assistance there if we can get.
Yes, as I understand the question, let me just answer it this way. The initiation of these misconduct proceedings, it appears to me they can be initiated by the executive. The proceedings are now going on. It will be problematic if during the investigations, or let's just say a hearing, that the views or the evidence or anything that has got to do with Umdeni is not considered before the final decision can be made.
But the provisions of the Act, are they capable of being interpreted to say what you say?
Yes, because at the end of the day, what's going to happen at the end of this inquiry or the investigation, the final decision will have to be made by the executive.
Which would have initiated the inquiry in relation to this one offense?
Yes. Let me just put it this way. On the initiation, they can. It appears that they can. But the problem is, after the initiation, there must be these investigations, evidence gathered, witnesses consulted, relevant evidence being considered, and then there's a decision. So the problem will be with the decision. If that decision is made without involving them during either the hearing or the investigation, that is why we submit that it is a court of review matter. It's not a setting aside of a legislation.
Thank you, Mr. Chair.
Thank
I don't think I understand you. On the, apropos what you were discussing with my brother Nook, is that your submission that there would be an initiation by the executive? And that initiation would lead to investigation and evidence gathering. And if during the process of evidence gathering, the Umdeni is not included, that would be problematic. And if I've captured your submission correctly, how does that submission assist us in the interpretation of the impugned provisions?
Yes, if after the investigation a decision is made, that decision has to have taken into account the relevant factors. And depending on what type of a misconduct, the relevant factors will, at a particular stage, for an example in this matter, have to include the Umdeni. But there might be, if we reach that stage where the Umdeni is not a relevant party or a relevant can bring relevant evidence. For an example, drugs and intoxications. I don't see what role will they play.
So then, let me interrupt you.
Yes, yes.
So then, what pathway, legal pathway, ought to have been followed by the applicant? You would say it's not seeking constitutional invalidity, but they would locate their remedies under legality or PAJA. Because you would say, if they do not, or they did not consider the considerations of the Umdeni, then that decision would be tainted on the basis that irrelevant considerations were not considered. Is that what you say?
Yes, basically that's what we say. That the problem is not with the legislation, the problem was with the application.
No, it's a quantum leap.
The application of this section, if a decision is going to be made by the executive, ought to take into consideration relevant issues, evidence, and especially in these circumstances, the evidence that was really necessary was the evidence of the customary law of the area. So there will be circumstances where there, for an example that I've given, the intoxication and the drugs, I suspect in that type of a scenario, their evidence might not be necessary. The executive might end up making a decision without them of guilty or not guilty.
Let me test if I understand you. Is that your principal argument, that the pathway that has been chosen should have been PAJA, not constitutional invalidity, or it's a secondary fallback position?
It is not. It is the main way.
It's the main one.
We are saying if the legislation is capable of this constitutional remedy, then it can be struck out for being unconstitutional.
But you've had the debate and the questions that have been put to you as well as your learned colleague. And is there any way that it can be safe if one were to proceed on the basis that you are suggesting on PAJA? Will that legislation be saved?
Yes, the legislation, if I understand the question, there are two. We are saying the legislation should not have been challenged because their remedies lie somewhere else. The legislation is constitutionally compliant because failure to apply legislation properly has remedies somewhere else. So if they are going to challenge the legislation, then we submit that this court ought not to agree with them because the interpretation does not lead to only one interpretation, which is the exclusion, which is part of the application.
Thank you.
As my please, Chief Justice.
Thank you very much, Mr. Mujapid.
I beg your pardon?
Oh, you've got instructions.
I've got the instruction. Yes, this is a draft proposal on the reading in. May I just consider it before I read it? Thank you. Thank you.
Okay. Thank you very much, Mr. Mujapid. Mr. Naidu?
In response, the first thing I would make reference to is we mentioned that the provincial legislature is itself a self-contained legislature and subject to governance by this court, was also dealt with in the city of Cape Town and others versus Robertson and others in 2004, ZACC 21. Just for completeness, I mentioned that. And we submit that if one deals with any reading down which has the effect globally in the legislation, of preventing the Premier, the EXCO, and the MEC that they may not play or initiate conduct or acts which in customs or customary law matters, including traditional leader matters, are decisive, then that might be a means of reading into the legislation where, for instance, reference to Premier taking a decisive role is rather placed in the hands of the Umdeni Wenkosi, where it should reside. And in my learned colleague's argument, for instance, at paragraph 39 and 40, which was referred to, it is stated that the statutory scheme applied marginalized customary authority in paragraph 39 of the submissions. And then we see that in paragraph 40, there is talk of returning the decision-making power back to the Umdeni Wenkosi. And the scheme of the submissions in the submissions is, in fact, that the Umdeni Wenkosi is the repository of the real power when it comes to appointment and removal. And to elevate the notion of recognize to one containing in itself a decision to appoint is wrong. And when the Umdeni Wenkosi says, we require you, Premier, to recognize so-and-so, the Umdeni Wenkosi is not making a recommendation. It is effectively saying, in our authority, we direct that you appoint so-and-so. And it is for the Premier then to, if he has a complaint, to remit this matter back to the Umdeni Wenkosi. And in the scheme of this 2005 Act, it is the Umdeni Wenkosi throughout the appointment, and we submit the removal, which bears the decision-making power. All the submissions made by the amicus also rests on the premise that the Umdeni Wenkosi should merely be heard. And this is based on legislation itself, which was created ignoring the provisions of the customary law. And we say that is something which has now been recognized by the legislature, which has conceded that it has, as stated by my learned colleague at page 14, paragraph 39 and 40, that they have marginalized customary law in making this legislation, that is the Kwazulu-Natal Act of 2005. And that statutory scheme, so to speak, which reposes decision-making power in the hands of the individuals, the respondents in question, that is the EXCO, the Premier, and the MEC, is ideally amended by striking down the provisions we ask to be struck down. Again, when there is this analysis that is reference to interested parties, namely the Umdeni Wenkosi being at the same time the repository, the keeper, and the knowledge bearer of customary law, and in that instance should be made merely as a bystander or a witness, that would be a perversion of the customary law being enacted in a legislation. And the analysis there is on a flawed basis. In other words, you take the flawed, incorrect act and use that as a basis for justifying and making correct the so-called independence in particular actions by the EXCO, the Premier, and the MEC. In the time I had to deal with how amendments can be done, if one does justice to the community and the communities affected by what the Constitution legislates in their favor, what the Constitution gives them, then the way one could deal with this is in a generalized way to say that where the Premier, where the EXCO, and where the MEC have anywhere in this Act arrogated to themselves, directly or indirectly, decision-making power which vests in terms of the customary law in the hands of the Umdeni Wenkosi for themselves, that falls to be amended and returned to the hands of the Umdeni Wenkosi. And that is why we've mentioned before that given the concession made by the people who made this very law and their willingness to amend it, we submit that insofar as that may be feasible, and we submit it is feasible, the order should be granted as prayed, and let the legislation be made by the legislature instead of the court, so to speak, having to legislate again. And this is, in other words, amending a document which, in its scheme, causes power to reside in those who should not have the power in the first place. And it's no good taking theories of who is independent, who should be the court, and who should be the prosecutor in trying to now justify an act which in the first place should not have been legislated as it was, as admitted by the legislature in question. Those are the submissions I would make in response.
Thank you, Mr. Naidu.
Thank you, Deputy Chief Justice. With your permission, I wondered if it would be more useful and do justice to the court if both counsel could take their time, because it's an important issue, and consider what kind of reading, in, if any, would be appropriate, because I think they're sort of doing it with respect on the trot, and I don't think that does justice to what we are required to do at the end of the day. So subject to your view, that's a suggestion I make. And the other is just the observation I wish to make, if I may. Mr. Naidu,
Yes.
in your address in chief, you referred to the legislation in question
Yes.
as fraudulent legislation, correct?
When I said
I'm just wanting
fraudulent,
to ask you, is that what you referred to?
no, when I was referring
Sorry,
to
Mr. Naidu,
fraudulent,
myself and other colleagues heard you referring to it as fraudulent legislation.
Yes.
Is that correct?
yes, that is correct. I mentioned the word
I
fraudulent.
just want to say that I never picked up that that was part of the case advanced by your clients. And I think to accuse in the highest court of the country an organ of state that is charged with upholding the Constitution of acting fraudulently is, well, with,
No, I'd admit it's going too far, yes.
well, it's going considerably too far. That's all I want to say,
Yes.
Mr. Naidu. I think it
But-
wasn't appropriate.
Yes, what I was saying is this.
Could leave it at that.
We
It's not
have,
what
we
it's not
have,
what you were saying, it's what you said, Mr. Naidu, and I
Yes.
don't think we need to get into a debate on that.
but I must respond and say something on what you said, Justice Kolapan. And what I wish to say is this. The persons making this legislation know what the customary law states. The customary law states that the power and decision-making power vests in the Umdeni Wenkosi. Knowing that, what happens? They make legislation in terms of which they arrogate to themselves, without due process, the power which vests in the hand of the Umdeni Wenkosi.
Mr. Naidu,
And I
that's
posited that
that's been part of
against...
your argument, and all
I
I'm saying
have
to you,
to
Mr.
say
Naidu,
this.
is that that wouldn't constitute fraud.
I posited that
Mr. Naidu,
against
Mr. Naidu,
the CASAC.
Naidu, I'm talking to you.
I beg your pardon, my lord.
Can it stop there?
Yes,
Thank you.
thank you.
I see there are no other questions. Thank you very much.
Thank you.
Judgment is reserved, but before we adjourn, I just want to put it to both sets of counsel to say, I think Justice Kolapan makes an important suggestion that you put your heads together and see if you can produce something for us by next week, Tuesday, if possible.
Yes, we should.
I request that you do that.
I've spoken to my learned colleague. We'll do that. Thank you.
Thank you very much. The other issue I want to mention is we routinely request assistance from the bar to assist us, especially where there's been no opposition. We have now, I think this was the third, if not the fourth request to the Tshwane Society of Advocates to come and assist us. And the response has been very positive. So I want to thank you, Advocate Mujapilo, and the team that you have assembled. And please convey our appreciation to the leader of the group, that we appreciate that whenever we make the request, we receive a positive response. And I also want to thank you for bringing in junior members of the bar to come and watch you in action. That's good because you're blooding them into how things are done in this court. So that said, the court adjourns. Thank you.
Thank you. Hello. Oh, okay.
Yeah, this is what Bati has drafted. This is the way it is that.
Oh, okay. Yes.
Don't you want to